Happy New Year. On behalf of Operation Rock, this is Clayton back with the first live cast of the year and adhering to my promise. A couple of days ago, I discussed a case called Monell versus the Department of Social Services. It's a landmark case that allowed a civil litigant to be able to sue municipalities for the I would say errors, for the intentional civil violations, and for the wrongdoing of its employees. Up until Monell versus the Department of Social Services, it was impossible for a litigant to actually sue a municipality, like let's say the city of New York, the city of Chicago, the town of Woodbridge, etc. Case law had incorrectly interpreted. Excuse me. Case law had incorrectly interpreted the Civil Rights Act of 1871, and Section 1983 to exclude municipalities as being held accountable for the actions of its employees and officials. Versus and I'm sorry, and we're back. I'm sorry for that brief break. It was determined that a municipality could, in fact, be held liable for the actions of its employees if the municipality. I'm sorry, people. I am having one of those mornings where it will not shut up. Okay, so in Monell versus the Department of Social Services, it was determined that a municipality could, in fact, be held liable for the actions and the errors in the wrongdoing of its employees. This case involved, God, why is it doing this morning, people? I don't get this. It will not allow me to go into my settings. Like, what is up? There we go. Okay. All right. Sorry for that. There we go. We're good to go now, people. All right. Beautiful. Okay. So, Monell versus Department of Social Services was a case where several women were forced by the city of New York to go on maternity leave prematurely and without pay. These women felt that this violated their civil rights. The city was kind of forcing them to take these early maternity leaves and not paying them. So they decided to sue the city of New York. If you want to know more about that case, you can go back to my live cast from the 26th, I believe it was, the day after Christmas. But Monell versus Department of Social Services was a landmark case that allowed civil litigants to, in fact, sue a municipality and hold them liable for failing to train or properly inform their employees regarding civil rights and the laws of the land. How does this affect those of us who have been violated by the police or by the family court? Well, the decision of Monell versus the Department of Services allows just because I'm sorry, my connection went out again. I am out of the country, people. I'm in Colombia. Forgive me. So, but just because you're a man or you're a victim that they don't favor, they don't have the right to deny you or deprive you of due process. So, by way of the complaints, you can basically see that the nature of the action. This action is brought under 42 United States Code 1981, 1983, 1985, 1986, and 1988, as well as the Fourth, Fifth, and 14th Amendments of the United States Constitution, the New York State Constitution, the New York common law. Plaintiff seeks redress for systematic constitutional violations, including false arrest, malicious prosecution, intentional infliction of emotional distress, abuse of process, defamation, negligent supervision, and failure to intervene. And people, Michael McMahon in the NYPD, the officials of Staten Island, did every word of this complaint to me. And what they did was use social media and the power of their office to try to bury this so that the community and just, I would say, civil justice would not prevail. They made a mistake when they misjudged Clayton Howard's intelligence, and I'm going to prove it by beating them into submission to admit that Francina Evans was harassing me. So let's go forward, people. As you can see, I already told you the parties, so we can go past that. You don't need to know the parties. The jurisdiction. Jurisdiction is important in federal actions, people. You have to find out which district court or which federal court controls you. In New York, it's the Eastern District of New York and the Southern District of New York. In New Jersey, it's the New Jersey District Court. New Jersey just has one thing, New Jersey. You can either go to Newark or you can go to Trenton. Every state has its own. You'll have to look at your local state's district website and figure out how and what venue you need to charge the prosecutors or the police who have violated your civil rights. And it won't be hard. A simple Google search of your local federal court will tell you exactly what you need. There are also local rules you need to abide by. All of that will be displayed on your local federal district court website. So I totally recommend you do the research and figure out where your federal district is and the process to which they accept the complaint, because that's the first thing you're going to need to know. The jurisdiction is founded in the district court according to 28 United States Code 1331. That's a jurisdictional code used to establish jurisdiction in federal civil complaints. All of these are things that you're going to have to know. But truthfully, people, you won't have to worry about this. The only thing you're going to have to worry about is the factual allegations and the charges. So Plaintiff Howard is a victim of domestic violence committed by former girlfriend Francina Evans. Mr. Howard and Ms. Evans were involved in a contentious and abusive relationship that culminated in legal action. And unfortunately, people, that's partially true. Because the truth is, me and my ex-girlfriend had a great relationship up until I decided to end the relationship because she had no way of dealing with her abusive and psychotic mother who was stalking me. Now, again, all of this is evidenced through the recordings of my ex admitting how her mother and grandmother were admitting her, proof that her mother was stalking me, proof that her mother was lying on me and harassing the living hell out of me simply because me and this woman were getting closer in a relationship and her mother was jealous she was home by herself. See, people, the city of New York is about to lose millions of dollars, all because a woman was heartbroken because her ex-boyfriend dumped her because her mother would not let her grow and become a woman. This is the entire reason Francina Evans launched a war on me, people, because she was afraid to stand up to her mother, and her mother did not want her to leave. People, again, I'm in Colombia. My connection goes in and out. So the whole reason the Richmond County DA's office is being sued is based off an immature liar who refused to stand up to her mother, who was incredibly abusive towards her and controlling her life. So once I broke up with her and she realized I was serious, she started lying on me to the police to hurt me because she realized I was not going to go back with her. And this is the truth, people. So me and this woman become involved in a horrible domestic dispute, people. I am spending months arguing and begging this woman to just give me back my dog and go on with her life. But see, people, this woman knew that I loved the dog and that I would not give up without the dog. So she held on to this dog despite the fact that she knew the entire time it wasn't hers and lied to everyone around her and told these people that I gave her this dog. Now, despite the fact that I had proof, definitive proof, Months after Christmas, where this woman alleged that I supposedly gave her the dog for Christmas, people, I had text messages 3 months after Christmas in March, where the woman not only admits that the dog is mine, but asked me money for the diapers because the dog had had its first menstrual cycle. People, that's a clear indication that this woman was aware the dog was not hers. But that wasn't enough for Michael McMahon and the racists of Staten Island. No, people, they were angry that I wanted my dog back as the actual owner of the damn dog, people. So what they did was villainize me for wanting my actual property back, despite the fact that they knew this woman had stole the dog and tried to use it to force me to sign over shares of a business that she and I legally owned on paper. And this is the truth. So people, we start this whole thing. She starts, New Jersey charges her with theft. She immediately runs to Staten Island, files a fictitious petition in the Richmond County Family Court, accusing me of numerous allegations of domestic violence, hoping to obtain an order of protection. Now, this woman does obtain an order of protection based off this false petition she files in the Family Court of Staten Island. She uses this petition for over a year to launch a litigation war against me that goes back and forth between New York and New Jersey, culminating on December 1st of 2022, as you can see from the factual allegations in front of you, when I secure a final restraining order against my ex-girlfriend in New Jersey following a trial that established her harassment and abusive behavior. This FRO I won at the state of New Jersey, as you can see from the factual allegations under the Violence Against Women Act, VAWA, was registered in New York and federally enforceable. Despite the protective order, Ms. Evans repeatedly violated the terms by engaging in harassment, defamation, and false reporting against me, Mr. Howard, which the Richmond County DA's office knew. Specific violations include, and let's go to the next page, filing false complaints with the NYPD accusing Mr. Howard of threats, harassments, which were later disproven by evidence. Continuing her harassment campaign through public statements and social media posts designed to tarnish Mr. Howard's reputation. Ms. Evans filed a complaint with the NYPD alleging Mr. Howard engaged in threatening behavior. Detective Joseph Quirk arrested Mr. Howard based on these allegations, despite evidence that the claims had been dismissed in a prior New Jersey case for lack of merit. The arrest caused Mr. Howard humiliation and reputational harm, even though the charges were ultimately pursued. Ms. Evans filed another complaint alleging Mr. Howard made threats of violence. Detective De Palma arrested Mr. Howard, disregarding CCTV footage and witness affidavits that proved his innocence. Mr. Howard was detained for 7 hours, causing further emotional distress and professional damage, which is true, people, because I missed an incredibly important meeting that day with some suppliers in New Jersey that cost me thousands of dollars. See, people, Francina Evans was effectively able to destroy my legitimate income by lying on me and accusing me of domestic violence offenses she knew I was completely innocent of. This is the trash that comes from the womb of her mother, Laura Owens, the liar who pretends to be a woman of God and hides under a corrupt, wife-cheating thief of a pastor who is Victor Brown. This is the woman who everybody in the borough of Staten Island supported in her movement. Breaking up is not a crime. I'm sorry to tell you, officials of Staten Island whose political careers are in jeopardy, she lied to you. The only crime that was committed was when I broke up with her, when she began lying on me to the police and trying to have me falsely arrested to destroy me, so I could not be happy with any other woman, because that's what she actually said to me in text message, which is going to be revealed in civil court. Plaintiff's final restraining order and defendant's initial fares. On or about December 1st of 2000. I'm sorry, people. This area of Columbia has horrible Wi-Fi. It goes in and out every 15 minutes. So just bear with me. Today, I promise you, we are going to completely walk through a complaint involving the false arrest and the malicious prosecution by local district attorneys and police, so you know what to do if this happens to you. Plaintiff's final restraining order and defendant's initial fares. On or about December 1st of 2022, plaintiff obtained a final restraining order against Ms. Francina Evans, in New Jersey, following a 3-week trial that substantiated her harassment and abusive behavior. For those of you who don't understand what that means I was able to prove that she was harassing me and lying through her teeth. The FRO was federally recognized under the Violence Against Women Act, 18 United States Code, subsection 2265 through 2266, and registered in New York to ensure the enforcement across state lines. Despite this, NYPD officers at the 120 precinct, like I've been telling people for 2 years, consistently refused to enforce the FRO, claiming jurisdictional limitations or providing no justification. Plaintiff made several reports of Ms. Evans involving violating the FRO, including instances of harassment, defamation, false reporting. These violations were documented but ignored by law enforcement. See, people, Staten Island had a conspiracy to protect Francina Evans, and they're about to pay through their ass for it. Excuse the profanity, people, because I am angry. My civil rights were violated, and I want justice. And since Michael McMahon and Darren Albanese, the Staten Island District Attorney's Office, the Staten Island NYPD, Safe Horizon, and these officials that protected Francina Evans refused to expose her for the lies that she did and the damage that it did, defaming my character, I choose to expose them all through civil litigation. This civil action, as you can see, which has a case number and is filed and is going to be going to trial. False arrest and malicious prosecution, May 16, 2023 arrest. Plaintiff was arrested by Detective Joseph Quirk based on allegations filed by Ms. Evans that had been previously dismissed in New Jersey courts. Remember, I mentioned earlier, people, territorial jurisdiction. Detective Joseph Quirk could not arrest me for allegations that occurred in New Jersey, but this racist bastard did because he felt as a white man he could have me arrested as a cop because I was a black man with a criminal record. He was wrong. Plaintiff provided documents demonstrating that the charges were dismissed for lack of jurisdiction and factual basis, but Detective Quirk failed to review or acknowledge this evidence. Plaintiff also provided documents to Mackenzie Upshaw of the Richmond County District Attorney's Office. Plaintiff was erroneously informed by Ms. Upshaw that the New Jersey FRO registered within the Richmond County Clerk's Office was unenforceable within the state of New York and denied its protections. And people, Mackenzie Upshaw did this. I have played the recording. It is on my page. Mackenzie Upshaw lied to me and told me that the New Jersey order, which was registered in Staten Island at the time she and I spoke, wasn't enforceable in Staten Island. Therefore, anything Francina did to me with regard to that order of protection couldn't be honored. And Mackenzie Upshaw lied. The order of protection was enforceable. Courtney Chase lied. I was the victim recognized by federal law, but Staten Island refused to accept my victimhood because I was a black man. And the truth was these biased women within the Richmond County DA's office were biased towards male victims of domestic violence. And some of them were personal friends of Francina Evans who believed her despite investigating her allegations. So they lied to me and tried to deprive me of justice and federal protection from the order of protection. And this is why many of them are about to be held accountable, especially Mackenzie Upshaw, because that recording is going to civil court. She said that. I have a recording. She's done. And I don't mean done as far as her life. I mean, career-wise, she might have a problem with the lies she told me. Plaintiff reached out to Safe Horizon within the office of the Richmond County District Attorney's Office and was further denied services and informed the active SRO was enforceable within within New York State. Again, people, true. I have shown this evidence on my page and throughout my time advocating against the civil rights violations of the Richmond County DA's office. Plaintiff was detained, humiliated, and released without further action, but the false arrest damaged his professional reputation. And I was actually prosecuted, people, for over 8 months for this arrest, despite the fact I had all of this evidence to prove that the allegations of my ex-girlfriends had been dismissed in New Jersey and that she lied. She claimed I filed false child abuse charges of her, people. Well, guess what, people? I'm also in New York family court with the mother of my child, who has been accusing this woman of physically assaulting her daughter for the last 2 years. Do you really think that the NYPD and the Staten Island District Attorney's Office couldn't contact Brooklyn or look in the city of New York's domestic violence system or family court system and review the documents filed by the mother? Of course they could, people. But the point was they didn't want to expose Francina as a child abuser. They didn't want to expose me as truthful. What they wanted to do was violate my civil rights because the office of Michael McMahon is inherently determined to violate the civil rights of. We're back again. The office of Michael McMahon is inherently determined to violate the civil rights of African American men. So on November 17, 2003, people, I was arrested again. Plaintiff was arrested again by Detective Joseph DePalmo following a fabricated complaint by Ms. Evans alleging threats of violence. despite clear exculpatory evidence, including CCTV footage showing plaintiff was elsewhere at the time of the alleged incident, the witness affidavits corroborating his incidents. Detective De Palma detained the plaintiff for 7 hours. And let me tell you something, Detective De Palma was not going to arrest me. That racist, bald-head bastard was going to run me through the system and have me charged with violating Francina, even though the camera footage from the Richmond County Court proved that I was never near her outside the day she claimed I threatened her and her family. People, I left the court 20 minutes early, and there's footage showing me walking to my car, getting into my car, and I have a toll receipt for the exact time Francina says I threatened her outside the Staten Island Family Court, proving that I was crossing into New Jersey and nowhere near the Richmond County Family Court. But was that enough for Detective De Palma? No. My black skin was enough for him to ignore the truthful exculpatory evidence, and exculpatory means that it exonerated me of criminal liability. Instead, he charged me and tried to ignore the CCTV footage. Luckily, again, John Rappaway and Francine Scotto, my attorneys, fought the 120 precinct and literally told them, listen, you guys are lining yourself up for $1 million lawsuit. You're idiots. She's lying. And guess what? Faced with the threats of legal counsel threatening them with civil action, Detective De Palma finally went to the CCTV footage, which he should have done from the beginning. It is the family court. He does have access as a detective. He reviewed it and realized Francina lied, and he was forced to release me. This is why they are being sued for that arrest. Systematic negligence and malfeasance by the NYPD and Richmond County DA's office. For terms of this lawsuit, RCDA is Richmond County District Attorney. Plaintiff filed multiple complaints with the NYPD 120 precinct against Ms. Evans for harassment, false reporting, and violation of the FRO. Several complaints were documented but not investigated, while others were deleted or mishandled without exception. Examples include on August 1st, 2002, plaintiff reported Ms. Evans for violations of the FRO, which was then a temporary order when Ms. Evans contacted the mother of the plaintiff's child despite the order forbidding her to do so. A warrant was issued by the 120 for the arrest of Ms. Evans, yet by the 120 for the arrest of Ms. Evans, yet someone after Ms. Evans was found to have violated the New Jersey Prevention of Domestic Violence Act. Actually, wow, my lawyer made a mistake. That should be somehow after Ms. Evans was found to have violated the New Jersey Prevention of Domestic Violence Act. This warrant was dismissed, and Ms. Evans was allowed to file a report against me, the plaintiff, for allegations proven untrue within the state of New Jersey. This is the first example of dismissals of charges against Ms. Evans where no justification was provided despite probable cause. October 31st, 2023, plaintiff reported contact by Amina James, a personal friend of Ms. Evans, who made third-party contact to the plaintiff for Ms. Evans to threaten him with criminal action if he refused to dismiss the active prosecution against Ms. Evans and dismiss the active FRO. This report disappeared with no record being found. And people, that's the truth. I reported this to the Staten Island 120 precinct on January 31st. People, the report disappeared. They have no record of it. They couldn't find it, and they refused to locate it for me, forcing me to refile it again in June of 2023. June 6th, after almost 6 months of inquiries to the NYPD and complaints, the plaintiff refiled the information contacted in the previous referred complaint with P.O. Joseph Noto of the 120 precinct. P.O. Noto would intentionally misclassify the location of his complaint so that it would be sent to the 122 precinct and not investigated by the 120. People, this is a fact, and I have because this little shit is not a detective. I have Officer Joseph Noto on recording admittedly lying to me about this complaint. And people, guess what? Clayton was smart enough at this time that when I went into the 120 precinct, I was wired with a microphone. So the whole time I sat in front of Officer Noto and talked to him about the complaint, I was recording it. So when Officer Noto lied to his superiors and said that I told him it happened by the 122 precinct, I just gave them the recording of me telling him it happened in the Stapleton, that I received a call from Francina's fake attorney in the Stapleton post office, which would have given jurisdiction to the 120. Okay, so plaintiff was contacted by a detective from the 122 squad, and after being interviewed, informed that P.O. Noto had misclassified the location of the incident and that the 120 precinct had jurisdiction. Therefore, the report was transferred back to the 120. Despite this attempt, officers within the 120 refused to reopen the complaint until plaintiff filed a complaint with the Internal Affairs Bureau. People, again, I just said it. This complaint was filed. This officer Noto of the 120 domestic violence unit falsified my complaint, so it appeared it happened in the jurisdiction of the 122, and it would be out of the 120. Because remember, the 120 was in my ex-girlfriend's pocket. They were helping her file false complaints, helping her falsify evidence against me, falsify narrative against me. This is the truth, people. So this detective, not wanting to have me into the same domestic violence unit that was violating my civil rights for my ex-girlfriend, decided to lie and falsify my complaint. So my complaint would be sent to the 122. The 122 said, hell no, this happened in the Stapleton post office. You guys have jurisdiction. But instead of them actually doing the right thing, they still refused to open my complaint until I filed a complaint with the Internal Affairs Bureau. Guess what, people? I got some action then. They opened my complaint. So in July of 2023, the plaintiff reported contact from Ms. Evans informing the 120 of the late night incoming call where he had been able to identify her voice. Plaintiff provided verification of a copy of the call and a copy of the active FRO. Despite this, Ms. Evans' violations were dismissed without investigation and sealed. On November 17th of 2023, plaintiff attempted to report against Ms. Evans for false reporting complaints, but the report was deleted by the NYPD system of the 120. So people, I made this complaint against Francina for falsely reporting me, and the 120 deleted it because they did not want her to be prosecuted. See, people, now they're going to answer. In February of 2004, upon the advice of criminal counsel John Rappaport, plaintiff reported the May 16, 2023 arrest as a false report within the 120 precinct, providing certified copies from within New Jersey courts to officers within the 120 precinct as exhibits to verify previous adjudication and complaints of Ms. Evans. Despite the plaintiff's charges being dismissed on October 30th of 2023 in relation to the May 16th arrest, the report, Ms. Evans, was closed without. Yeah, my lawyer made a lot of typos here. I just see that because he drafted this, people, not me. I make mistakes too, but he made some mistakes here. The arrest reported against Ms. Evans was closed without justification. See, people, she had me falsely arrested. I proved it was a lie. I proved it happened in New Jersey, and I proved she intentionally traveled from New York to New Jersey after she was found guilty and lied on me. But the racism and bias of Staten Island and Michael McMahon's office refused to hold her accountable for the actual criminal offenses she did. Excuse me. Internal recordings and emails show officers, including Officer Noto, Sergeant Imperatrice, and several other ranking officers admitting the plaintiff's report were mishandled or intentionally ignored. People, again, I have recordings of these officials telling me that the DA's office was dismissing and concealing my complaints because they were protecting Francina. And I have this on tape from Sergeant Imperatrice and several other sergeants and actually a lieutenant, by the way. I also have a lieutenant that I had on tape telling me the DA's office was after me and to be careful. People, I'm not playing with Michael McMahon. He wants to be a racist. He wants to violate my civil rights. I'm going to expose him to be the racist clown he is. The Richmond County District Attorney's Office, RCDA, led by individuals including Mackenzie Upshaw, Courtney Chase, Lisa Thompson, ADA Gabriella Giovinazzo, and Michael McMahon, actively suppressed exculpatory evidence in the plaintiff's defense while pursuing baseless charges against him. People, like I told you, Michael McMahon and these people were after me. They were hell-bent on proving Francina Evans was a victim, knowing she had been convicted in the state of New Jersey, and that the allegations of abuse were being substantiated by the mother who was reporting her in Brooklyn Family Court. But what Michael McMahon did was do everything in his power to bury this information and keep it from the eyes of the public so Francina would receive the benefits of being a victim. The Richmond County DA's office creates fictitious victims to violate the rights of minority men and men overall. And my mission is to expose them and to remove Michael McMahon for the procedural and statutory due process violations committed by his office with his authority. The RCDA, in collusion with members of Safe Horizons, attempted to destroy the plaintiff's credibility and publicly honored Francina Evans as a domestic violence victim despite her documented history of harassment and false reporting, further emboldening her retaliatory actions. Again, people, Many of you remember who followed my case. Francina was honored at St. John's University, where she gave a speech about me coercively controlling her. The truth is that entire speech was a lie, people, and the Richmond County DA's office knew the truth. But what they did, because Francina had the platform and the weight of Safe Horizon and the district attorney behind her through the connections of her corrupt pastor, Pastor Victor Brown, and the pervert Michael McMahon, they put her on the podium because people, why would the public not believe this girl was a victim if Safe Horizon and the DA's office was honoring her as victim of the year? Of course, everyone would believe she was telling the truth, people. How could she be telling the truth? Recently having been convicted of harassment and also the appeal being denied and multiple charges being against her, plus the mother of the child accusing her of abuse in Brooklyn Family Court, which is huge, people, because again, I was accused of falsely reporting this woman. Well, people, what about the mother? What about the mother of the child who has been reporting to the Brooklyn Family Court for 2 years that Francina Evans assaulted her daughter? Why was no action taken by the Staten Island District Attorney's Office? Because the truth was, I was their target. They didn't care that Francina Evans was lying. Now I care to make them pay. Miss Evans has personal connections to Michael McMahon through NYPD clergy lieutenant Victor Allen Brown, who is the pastor of her church and also an associate of the plaintiff. Miss Evans used these connections to both frame and further pursue the plaintiff in continued effort at harassing and cause him financially loss. See, people, I told you, Victor Brown is named in this office. That's right, members of Mount Sinai Church. Your pastor is named in a federal civil rights lawsuit for what he did with Francina Evans. He did this, people. He is a liar, and he will be held to account, not only by God, but by the city of New York through declaratory injunction. Because, people, I'm going to get a declaratory order that states that Victor Brown, Michael McMahon's office, Mackenzie Upshaw, and the rest of the people named in this offer or this lawsuit violated my civil rights by conspiring to violate and deprive me of my freedom with Francina Evans. And that is exactly what Pastor Victor Brown of Mount Sinai Church did. He helped Francina falsify complaints against me, allowed her to use her church podium to defame not only me, but my deceased mother in an attempt to make me look as though I was abusing my deceased mother. This man is sick, and my mission is to expose him and break the strength of his church if it's the last thing I do with every ounce of strength I have. Victor Brown will be held to account for lying on me and helping Francina Evans lie on my mother. Miss Evans, despite being a documented domestic violence offender with an active order where her appeal had been denied and who was then facing active criminal charges for crimes committed against the plaintiff in the state of New Jersey, was allowed unrestricted access to the offices within the RCDA, while the plaintiff was barred from resources federal law mandated that the plaintiff receives as the documented legal protected party. People, again, I had a final order of protection that had been affirmed through appeal. I was the legal victim of the domestic violence dispute with Francina, not Francina. The lies of Francina Evans, the lies of the Richmond County DA's office, the lies that were fostered by Safe Horizon and the officials and advocates of Staten Island is why Francina Evans had the appearance of being a victim, because they were putting her on social media so you guys would ignore the factual basis of the case. Now they can't do that because this civil lawsuit is going to expose Michael McMahon for exactly what he is, a racist, biased, unjust politician who needs to be removed and placed with someone who truly cares about the rights of minorities on Staten Island. Victor Brown should lose his clergy position within the NYPD because the truth of the matter is he is there to protect the community, not set them up because he may be attracted to a young woman in his church, not set them up because he's afraid of the strength of the son of the pastor who was stronger than him and who literally is the reason that he has any credibility. That's what Pastor Victor Brown did to me, and people, he's going to pay. Miss Evans, despite Miss Evans was also able to provide restricted documents from the office within the RCA that she attempted to include in New Jersey family courts hearings to further defame and slander the plaintiff. Specifically, Ms. Evans provided documents to the Essex County Family Court during a hearing on February 16th of 2003, where she alleged the plaintiff was being investigated on Staten Island by the 120 precincts for heroin trafficking. People, this woman was so desperate to get revenge on me, she lied to officers in the 120 and told them I sold heroin. So people, the possibility of arresting a black guy selling heroin was so strong to these racist bastards in the 120 precinct, they ignored every criminal criminal allegation against Francina just to try to charge me with heroin trafficking for something I wasn't even doing, people. That's how sick these racist, biased cops are on Staten Island, who violate procedural and statutory due process. And they made a mistake when they misjudged the intelligence of Clayton Howard. I am the son of a woman who's not going to let them get away with this shit, people, and I'm going to fight. So the plaintiff was never charged or arrested for heroin trafficking or a drug offense. Yet Ms. Evans possessed documents regarding an investigation never brought forth against the plaintiff. These allegations constitute a serious breach of office security within the Richmond County DA. People, I have the transcript. So the DA's office is not going to be able to lie and say Francina's attorney did not produce a document that alleged I was being investigated for heroin trafficking from the NYPD. Because people, they were trying to arrest me. They did everything in their power to try to prove that Francina was telling the truth. And the thing is, people, she wasn't. I wasn't selling no drugs when I met this girl. People, my mother had just died. I couldn't walk. I was broken, people. I was barely leaving my damn house. But this girl was so desperate because her heart was broken because a man left her because she's a little girl. She lied and tried to have him in prison for the rest of his life for being a drug trafficker for something he never did. And this is the girl respected by the Staten Island community. Anybody who respects her, you're going to deserve to fall with her when this lawsuit breaks Staten Island's biased judicial system apart. You will fall with her. Camilla Hanks, Charles Fall, Terry Troy, Victor Brown, Michael McMahon, Victor Brown, everyone who helped Francina Evans set me up is going to pay. Economic and emotional harm. Plaintiffs suffered severe financial loss due to defendants' actions, including the loss of $375,000 in business contracts for his company, Gold Standard Contracting, caused by reputational damage and false arrest. When I was arrested by my ex-people, I was arrested for a week for the lies of her I was arrested for a week for her lies in May, I believe it was, of 2003. Sugar went to shit. I'm just going to say it for what it is, people. I lost thousands of dollars because literally I was picked up in the middle of a major project I was performing in New Jersey. These people's house flooded, their basement got destroyed. The next amount you see for $32,678 is the actual amount I had to pay to rebuild these people's basement because of what happened, because Francina Evans lied on me and had me detained for a week. The loss of $9,000 in legal fees in the defense against the May 16, 2003 arrest. It cost me about 10 grand to get out of that. The inability to secure new clients due to the publicized allegations and repeat legal entanglements initiated by defendant's negligence. People, Francina was all over social media accusing me of abuse, people, and it was a lie. The Richmond County DA's office knew she was lying, but every time I would report the cyber harassment and the lies, they would ignore me. And this is what made me start my social media broadcast, people. It was a need to defend my reputation. The connection again, people. How else was I supposed to defend myself when the NYPD was actively ignoring the fact that Francina Evans was violating the order of protection and completely slandering and defaming me with allegations they knew were completely false? So, people, I took to social media, and I wasn't as good as first people, but I tried, people. I was trying to put the truth out because the truth was I had never abused this woman, and the police of Staten Island knew it, but didn't care because I was a black man with a criminal record they felt they could falsely prosecute, and they were wrong. The plaintiff has endured ongoing emotional and psychological harm, including severe anxiety and depression stemming from the repeated false arrests and failure of law enforcement to protect them. People, this has been a nightmare, people. I constantly woke up depressed, people. I had to dig down deep in my soul to find a higher authority than myself, which is God. I had to truly get reconnected with my spirituality again, people, or otherwise this situation would have broke me. And I probably would have lashed out and tried to hurt this girl because law enforcement would not work in people. I really got to a point where I felt that the only way this would stop would be a physical confrontation. This is why I challenged her punk brothers to a fight. I'm like, yo, listen, y'all keep lying for your sister. All right, why don't we do this legal? We step into the square, I pound you in your. Once I beat the two of you, then guess what, people? This is going to stop. So I challenged her brothers to a physical altercation, considering they kept approaching me like they wanted a problem. People, I wanted all the smoke with the Evans brothers, but they're cowards. What they did was help their sister lie to the courts because the truth is neither one of them are men. They're weak, spineless cowards, Bretton Evans and Matthew Evans, completely undeserving of the respect of men. And this is why neither of them will ever get my respect. A fear of future retaliatory actions by Ms. Evans, NYPD officers, and that of officials within the Richmond County District's Attorney's Office who have already colluded amongst each other to deprive the plaintiff of his rights. People, there was a massive conspiracy to set me up for allegedly domestic violence against Francina Evans. There was a conspiracy between Safe Horizon, the NYPD, Ronti Olagunki, Malcolm Penn, Mike Perry, Michelle, what's her name? Melissa Thomas, and this Rachel woman were Francina's core group that was helping her lie on me to the criminal courts of New York and family court, filing petitions and making allegations so I would be falsely arrested and detained. And people, it was a complete lie. This is why I have such problems with Malcolm Penn, Mike Perry, Ronti Olagunki, and every person who was involved in this. And people, I'm going to get my pound of flesh. Evidence of bias and discriminatory treatment. As a male victim of domestic violence, plaintiff was subjected to discriminatory treatment by both the NYPD and the RCDA. While Ms. Evans' false claims were prioritized and prosecuted without evidence, plaintiff's valid claims and compelling evidence were dismissed and ignored. The NYPD officers repeatedly failed to recognize the plaintiff as the victim, instead treating him as a suspect or aggressive without basis. Defendant's systematic bias is further evidenced by their refusal to enforce the FRO in favor of the plaintiff while aggressively acting on Ms. Evans' baseless allegations. Complete truths, people. They never enforced my FRO. Every time Francina was Evans, they would dismiss the case and seal it, even though she was contacting my child, falsifying complaints, calling me in the middle of the night, and there was proof she was lying. They never took action and prosecuted her because they thought that I was a poor, uneducated black man who was going to let them get away with this. And people, by God, on my mother Maggie Howard's soul, Michael McMahon was wrong. I am going to bring that racist bastard to his knees so he admits what he did to me. Him and that scumbag pastor, Victor Brown. NYPD and RCDA's failure to enforce protective measures. The NYPD's refusal to enforce the plaintiff's the NYPD's refusal to enforce the plaintiff's FRO constitutes a violation, of their obligation under the Violence Against Women Act, VAWA, and the New York State Family Court Act, subsection 842 through 844. Again, people, the NYPD and Richmond County DA's office had a mandatory obligation to respect my rights and enforce the FRO against Francina Evans. And what they did through corruption, through manipulation, through deceit, and through falsity was refused to provide me those protections and instead provide them to the offender and deny me the justice that I was correctly and justifiably entitled to after a trial where it was established that Ms. Evans had lied through her teeth and I was granted a lifetime order of protection to protect not only me, but my infant daughter who Francina Evans swears I lied on her about slapping. If I lied so bad, why has the mother literally accused her of the exact same thing in Brooklyn Family Court for 2 years? Something that the Richmond County DA's office knew and hid from the public. Plaintiff provided the NYPD and RCA with documentation of the FRO's registration and validity, yet they willfully ignored their duty to protect. The systematic failure to act on the FRO enabled Ms. Evans to file false reports, defame plaintiff publicly, and escalate her harassment campaign with impunity, which is 100% true. Missing police reports and evidence suppression. Plaintiff discovered that several of his police reports against Ms. Evans had been deleted or ignored, depriving him of his right to petition the government and seek justice. Officers admitted in recorded conversation that there was internal failures to document or investigate the plaintiff's complaints. Officers also admitted in recorded conversation to misconduct within the Richmond County DA's office and unfavorable treatment of the plaintiff while Ms. Evans was being protected by the Richmond County DA's office. Exculpatory evidence such as CCTV footage, witness statements, trial transcripts, audio recordings, and email communications were suppressed or disregarded by the Richmond County DA's office, undermining the plaintiff's ability to defend himself against the false charges, which was 100% true. People, before my attorney got in touch with Darren Albanese, I had submitted the transcript from New Jersey to officers Joseph Quirk, Officer Noto, and even attempted to submit it to the Richmond County DA's office through Lisa Thompson. And people, every attempt to provide the Richmond County DA's office with proof that the allegations happened in New Jersey and Francina was lying was ignored, because Michael McMahon was determined to prosecute me as an innocent black man, and he's going to pay for it. Defendants have a pattern and practice of engaging in similar acts complained of by the plaintiff. Plaintiff Clayton Howard's allegations are not isolated incidents, but are part of a broader, documented pattern of practice by defendants, particularly the New York City Police Department, in engaging in misconduct, systematic negligence, and constitutional violations. Investigations and legal actions have repeatedly identified failures by the NYPD and other city agencies in enforcing laws equitably, protecting victims, and ensuring accountability. Department of Justice (DOJ) investigation into NYPD Special Victims Division (SVD). In June of 2002, the U.S. Department of Justice launched a pattern or practice investigation into the NYPD Special Victims Division. The investigation focused on whether the NYPD engaged in gender-biased policies, failed to protect victims of gender-biased. Let's keep going. People, it took a lot of research to give this to this lawyer, but people, thank God I was intelligent enough to put it together. Gender-biased crimes and systematically mishandled cases. The GOG noted concerns about inadequate training, investigative fails, and inadequate enforcement of protective measures. Investigation by the New York State Attorney's Office. The New York State Attorney General's Office has conducted an investigation into the NYPD's treatment of civilians, particularly in contexts involving public safety and constitutional protections. These investigations highlighted systematic misconduct, including biased enforcement of laws and failures to safeguard the rights of vulnerable individuals, such as victims of harassment and domestic violence. Yours truly. Floyd versus the City of New York stop and frisk practices. In the landmark case, Floyd versus the City of New York, the court found that the NYPD engaged in unconstitutional stop and frisk practices, disproportionately targeting African American and Latino individuals. The court ruled that the department violated the Fourth and 14th Amendments, as underscored the NYPD's longstanding pattern of biased enforcement. Findings: racial profiling and discriminatory practices were institutionalized. Constitutional violations resulted from insufficient training, oversight, and accountability. Eric Garner case. Unfortunately, his mother, Gwen Carr, lied on me, but the son with her case is part of my lawsuit, because it further exhibits the NYPD's patterns of bias and injustice towards African American men. The death of Eric Garner in 2014 due to an illegal chokehold by NYPD officer highlighted widespread concerns about the department's use of excessive force and failure to hold officers accountable. Garner's death led to public protests, demands for reform, and further investigations into the NYPD's practices. Key issues identified: systematic use of excessive force, leniency in disciplining officers involved in misconduct. See, people, I made numerous complaints to Internal Affairs about Detective Quirk and Detective Palmer, about the investigations being deleted and dismissed, and them not actually complying with the FRO. And guess what, people? No action was taken, because the District Attorney's Office of Staten Island was acting as a protective shield, protecting Francina Evans from prosecution unjustly, despite the fact that she had been appointed the trial-ordered offender after trial of a domestic violence offense. They hid this from the public to protect Francina Evans and further defame me, and now they're going to pay for it. DOJ investigation into NYPD parking policies. In April 2024, the DOJ threatened to sue the City of New York over the NYPD's practice of combating parking, where officers illegally parked on crosswalks, obstructing pedestrian pathway, and causing difficulties for individuals with disabilities. The DOJ identified this practice as a civil rights issue and demanded immediate corrective action. See, people, these cops in New York were so arrogant. Everybody from New York, you all seen it. When the cops park in the middle of the street, when they take handicap spots, when they park in 2 or 3 places because they got a badge, they demand. No, you have to apply by the laws and regulations of the City of New York also. Just because you're a cop don't mean you can break the law and get away with it. So the Department of Justice is inherently aware that the NYPD is biased and prejudicial and violates constitutional and individual civil rights on a daily basis. NYPD leniency and disciplinary action. A court-ordered study revealed that the NYPD exhibited leniency towards officers involved in unconstitutional practices, including illegal stop and frisk. The report highlighted the inadequate accountability measures contributing to the systematic violations. to systematic civil rights violations. The facts outlined in these investigations and legal actions demonstrate that the NYPD and other city agencies have engaged in a pattern and practice of systematic negligence, biased enforcement, and constitutional violations. These documented practices mirror the allegations made by the plaintiff Howard, including the failure to enforce protective measures, biased treatment of domestic violence cases, and unlawful arrest based on insufficient evidence. People, again, this all happened to me. I was the victim. I was awarded a final lifetime, no contact, 1,000-foot restraining order against Francina Evans that to this day, the NYPD and Richmond County District Attorney's Office have ignored and allowed her to completely deny as though it is fictitious, knowing she was convicted after a 3-week trial. People, I'm going to bring all of this to the forefront. Since Michael McMahon does not have the integrity to own the mistake his office made, since Pastor Victor Brown, a man of God, a supposed man of the pulpit who stands every Sunday and tells his parishioners to love God and to love their community and respect each other, will not stand in his pulpit and tell the truth regarding Francina Evans, Clayton Howard will do it by federally suing the Staten Island District Attorneys in the city of New York for $11 million. Let's get it. Causes of action. This is important, people. So, people, as the first cause of action on behalf of the plaintiff, the 14th Amendment violations, false arrest, and malicious prosecution. People, when you are falsely arrested, that is a violation of your Fourth Amendment rights to a legal search and seizure. Even if someone makes a report on you, the police have a mandatory obligation to judge that report on what's called probable cause. Probable cause is defined as anything that would convince a reasonable person of another person's guilt. Now, granted, my ex was a domestic violence offender, a woman with no record who walked into a precinct with her 90-year-old mother and grandmother, accusing a black man with a past criminal record of physically abusing her. True, the officers could have acted on that. However, there were extenuating circumstances. My ex-girlfriend did this on December 5th of 2022. December 1st of 2022, she had been found guilty in New Jersey of violating the New Jersey Prevention Domestic Violence Act, which named her as the domestic violence offender. People, the fact that this woman walked into a precinct and used the day she was convicted to lie and tell the cops that I harassed her proved that the report was completely retaliatory. But Detective Joseph Quirk, the racist, incompetent, disgusting human being he is, ignored a federally protected order of protection and a state trial transcript and put charges on me anyway and an arrest warrant on me to arrest me for allegations Francina had been exposed to have committed in the state of New Jersey. Because, see, Detective Joseph Quirk didn't care, people. He figured that he was protected as a detective and he could just lie and say he was following probable cause. What that stupid racist bastard didn't realize is that I recorded and kept every piece of contact with him, and I'm going to hold his ass to the fire when we get in federal court. You want to be a liar, buddy? I'm going to expose you for the lying bastard you are, and we're going to go after your shield and your job. Hopefully, through this lawsuit, you are disciplined and taught to respect the rights of minorities and domestic violence male offenders and actually do your job and investigate cases, not falsely arrest black men because you're too lazy to do your job. And that's my mission by suing Joseph Quirk, the racist bastard he is. Plaintiff repeats and reiterates the allegation, and plaintiff reiterates and realleges each and every allegation contained in paragraph above with the same force and effect as though more fully set forth herein and at length. Legal standard and pleading requirements. The Fourth Amendment protects individuals from unreasonable search and seizures, including arrests made without probable cause. To establish a claim, whether 42 United States Code 1983 for false arrest or malicious prosecution, plaintiff must demonstrate the following. And people, this is important. If you ever want to sue the police for falsely arresting you or the district attorney for a malicious prosecution using 1983, you have to meet a set criteria in order for a federal court to recognize the possibility that this would have happened. 1, false arrest. The plaintiff must show 1, the defendant intended to confine him. 2, he was conscious of the confinement. 3, he did not consent to the confinement. And 4, the confinement was not otherwise privileged. Now, people, the Richmond County, the 120 wanted me to surrender for the false arrest of Francina Evans. And I said, hell no. I sent them a transcript. I sent them the court records, and I told them she was lying. Detective Joseph Quirk refused to accept any of that and kept the warrant on me. Now, this report was filed on December 5th of 2022. I wasn't arrested until May 16th, which means Detective Joseph Quirk had 6 months to review the information and evidence against Francina Evans. But guess what? He refused to do it. What he did was lie on me and withhold all of this evidence that proved that Francina was lying so I would be arrested. Now, here's the funny part. I'm sorry, people. This weather in Colombia has me so congested. Here's the funny part, people, and this is important. See, I was arrested. However, when this detective arrested me in May, he had the transcripts. He had all of the paperwork to prove that every statement that my ex-girlfriend made was a lie. But what he chose to do was pursue me because he knew I had a criminal record and it would be easy to get a conviction, or at least he thought so. Now he's going to have to answer to it in federal court. Intent to confine. The defendant intentionally confined the victim. People, despite the fact there was evidence against my ex, they confined me anyway. Awareness. The plaintiff was aware of his confinement. People, I was hell of aware that I was in jail. It was disgusting. They kept me in the 120 for days without sending my paperwork to court just to piss me off. Right, Joseph Quirk? If you're listening, you know you did it. And I pray that these videos reach them so they can see what they're about to go through. Because people, they did all of this. And they should not be allowed to hide behind the 11th Amendment immunities intended to protect truthful, procedure-abiding law enforcement officials and instead protect them as corrupt officials. No, the 11th Amendment immunities provided to law enforcement was not intended to protect corrupt law enforcement, people. It was intended to correct just law enforcement officials who needed to do their job without being, I guess, the weight of making the wrong decision being held over them. Not law enforcement officials who falsify police reports against victims so they would get arrested. Not prosecutors who withhold evidence so they can create victims and deny the actual victims their justice. No, people. This is what Michael McMahon's office in the 120 precinct did to me, and they're going to pay for it. No consent. The plaintiff did not consent to his confinement. Hell no, I didn't. No privilege. The confinement was not privileged or justified by probable cause. People, this man had no probable cause. Again, Francina had been convicted the day she claimed that I called her. She had no proof of a phone call. She had no record of a phone call. She only had her word. And as someone who had just been convicted in trial, her word was not credible. But to a white man wanting to arrest a black man for a false crime, Detective Quirk needed was to hear her allege these allegations against me. He never investigated them. He threw a warrant on me, and he diligently sought my arrest. So now I'm diligently seeking that he be held to a judicial account. Relevant case law. Relevant case law doesn't matter. Probable cause is a complete defense against a false arrest. True. If there are not any if there are not any, God, why can't I remember this term right now? Mitigating circumstances, which my ex's conviction 4 days before this report were definitely circumstances that this officer should have checked and was mandated to check by New York state and federal domestic violence law. He was supposed to check this, but he ignored the federal protections that I had and instead falsely arrested me so that the order of protection dismissed in New Jersey would be reactivated with full contact and with full privileges for my ex. So she would have another instrument to retaliate against me, which she did. Malicious prosecution. Plaintiff must establish 1, the initiation of a criminal proceeding, 2, determination in his favor, 3, the lack of probable cause, and 4, actual malice. Boyd versus the City of New York. Now, malicious prosecution works as follows, people. A plaintiff must establish 1, an initial criminal proceedings. Like I told you, on December 5th, this Joseph Quirk helped my ex Francina Evans falsify a complaint with me using complaints that had been closed out in the 123 and 121 and 123 precincts of Staten Island. He reopened these complaints in the 120 to include in his criminal complaint alleging that I had been harassing Francina over a year, despite the fact that the previous complaints that I'm mentioning had been investigated and enclosed and found to be fraudulent. He reopened them and withdrew that information out so I would be arrested by the 120 for violating Francina Evans, which is the initiation of criminal proceeding where he falsified a complaint, which is fraud committed by this detective. Determination in his favor. On October 31st of 2023, people, like I told you, the DA's office had to dismiss my charges after they were forced to review the transcript of Francina. Lack of probable cause. Again, people, my ex reported me on December 5th, alleging I called her on December 1st, the day she was convicted. People, there's no way I called her because I was in the Essex County Family Court with security camera footage, and court officials testified that I was there trying to find out what was going on with the decision I was waiting for, which later that day convicted her. People, the Richmond County DA's office knew this because we provided them with footage and an affidavit from the Essex County Court verifying between the hours of 9:30 and 12 o'clock on December 1st, I was waiting in the reception area of the plaintiff area of the Essex County Courthouse to determine if my hearing would be there today. I made no phone calls while I was there. There's security camera footage. I didn't get on the phone one time, but Francina lied to the NYPD and told them I called her. And because of this, Joseph Quirk, without any evidence, without any visual proof that I called her. Again, people, when you violate an order of protection, the police want to see proof that you got that call. Francina Evans didn't need that proof, despite the fact that she had just been convicted. No, her ex was a black man that this racist white cop didn't like. So what he did was arrest me anyway, despite the fact that she never even showed him I called her, nor did he have any proof I called her. And she had just been found guilty 4 days before that for harassing me. So people, it was terminated in my favor. It lacked probable cause. And yes, people, there was malice. There was malice because the Staten Island District Attorney's Office, knowing that I was innocent, colluded with the 120 to frame me and have me criminally charged, knowing I was innocent, because their mission is to deprive African-American men of their rights. I meet the criteria for a 1983 malicious prosecution game against the city of New York and the Richmond County DA's office. Thanks to Francina Evans. Let's give her a round of applause, people. Let's thank Francina Evans for all of the lies she told on Clayton Howard, because she's about to make Clayton Howard a millionaire. Let's go. Initiation of proceedings, termination in favor. We went through all that malice, blah, blah, blah. Relevant case law is Boyd versus the city of New York. Really interesting case, you people. You should look it up. Let's keep going. Facts supporting pleading requirements, the May 16th arrest. Intent to confine. Detective Joseph Quirk arrested the plaintiff based on allegations from Miss Francina Evans. The arrest was supported by a police report that falsely accused the plaintiff of threatening behavior and falsely reporting abuse within the state of New Jersey of his child. People, I'm in New York. It's the state of New Jersey. How could Detective Quirk arrest me? He couldn't, but he did because he thought I was an ignorant black man who would not be able to defend himself. And dude, you were so wrong. I can't wait till you eat egg, dude. No probable cause. Plaintiff presented documentation proving that the similar allegations had been dismissed in New Jersey courts due to lack of evidence. Detective Joseph Quirk ignored this documentation, arresting the plaintiff without investigating the veracity of the claims. Harm. Plaintiff was detained, publicly humiliated, suffered financial loss, and subjected to reputational harm despite absence of any evidence supporting the arrest. People, I never abused Francina Evans. I was good to her. And I'll be honest, I actually loved her to an extent until she did all of this horrible stuff to me. She is a horrible woman who deserves to be held to account for the lies that she told for 3 years. She should not be allowed to dance off into the sunset because family court and the criminal court of New York doesn't want to hold her accountable and expose their own statutory and just procedural due process violations. Since they don't want to do it, I guess I'm going to do it, people. I'm the son of thunder. That's what my mother always called me. I've always been incredibly aggressive, people. I love a good fight. And guess what? I'm knuckling in on this one. Let's go. November 17, 2003 arrest. Intent to confine. Detective De Palma arrested the plaintiff after Miss Evans filed another false complaint accusing him of making threats. No probable cause. Exculpatory CCTV footage and witness affidavits conclusively disproved the allegations, yet Detective De Palma ignored this evidence and detained the plaintiff for over 7 hours. Harm. Plaintiff suffered emotional distress, professional damage, and financial loss due to the baseless arrest and subsequent legal proceedings. Malicious prosecution. Intention of proceeding. The Richmond County District Attorney's Office, RCDA, pursued baseless criminal charges against the plaintiff based on Ms. Evans' false reports. Termination in favor. Criminal charges against the plaintiff were ultimately dismissed. However, these proceedings caused him significant harm, including legal fees, loss of business opportunities, and reputational harm. Malice. The RCDA employees suppressed exculpatory evidence, including CCTV footage, witness statements, trial transcripts, and ignored this evidence ongoing history of harassment to secure plaintiff's prosecution. These actions demonstrate reckless disregard for the truth and a deliberate attempt to harm the plaintiff, which Michael McMahon, Mackenzie Upshaw, Courtney Chase, and Albert Crawford did to me. And they're going to answer for it. Pattern of practice with constitutional violations. Defendants' actions were part of a broader documented pattern and practice by the NYPD and Richmond County District Attorney's Office of engaging in unconstitutional conduct, including arrest without probable cause and biased prosecutional practices. See pattern and practice section for detailed explanations. These systematic failures exasperated the harm suffered by the plaintiff, who was subjected to repeated violations of his Fourth Amendment rights. People, I was falsely arrested by Francina for the allegations of Francina multiple times without any probable cause, because her and her lying 90-year-old grandmother, this woman should have died years ago, people. This is, I can't say death is wished on anyone, people. But this old, miserable woman really needs to go meet her maker so she can have the peace that life has denied her for the last 60 years. She stalked her ex-husband for 60 years, and now she has helped Francina stalk me for the last 3 people. And Francina's going to pay for it one way or another, either criminally or civilly. Somebody's going to answer for what they did to Clayton Howard. Case law, the case law is irrelevant. Actually, no, I'm wrong. I'm sorry, people. Yes, I am wrong. 110. Defendants, including the NYPD and Richmond County DA's office, violated the plaintiff's 14th Amendment rights by falsely arresting and maliciously prosecuting him without probable cause. These actions, motivated by malice and enabled by systematic negligence, caused plaintiff significant emotional, financial, and reputational harm. Plaintiff respectfully seeks relief for these constitutional violations under 42 United States Code 1983, an applicable state law. That said, the occurrence and the resulting injuries to Mr. Howard occurred without fault or wrongdoing by the plaintiff, contributing thereto. That the aforementioned occurrence constituted an assault and battery upon Mr. Howard. They did, people. They battered my spirit by locking me up for a week for something I never did, people. I am horribly tainted. I have no faith in the criminal justice system. I have no faith in the legal system at all, other than the faith I have through the knowledge I have gained. I will never allow a lawyer to dictate my defense or my action again. I will do my homework, I will do my research, and then I will go to them, and we will confer like adults. Their expertise and their knowledge will always be accepted, because I'm not a master yet. I'm not a legal professional yet, but I'm getting damn good, people. And if I can't find case law and I can't find things that substantiate what my lawyer tells me, you know what I do now? I do my own research, and I come back at them with the case law that disproves what they say. And people, it's been working in family court, in criminal court, in civil court. People, I'm getting good. I really believe I have missed my calling. The defendants lack jurisdiction regarding the allegation of false reporting made by Ms. Evans, as it occurred in the state of New Jersey. The plaintiff provided documentation to substantiate this, yet was ignored. That as a result of the aforementioned false arrest, false imprisonment, and a malicious prosecution, excessive force, battery, and assault, and violent beating, plaintiff Howard, I ain't get beat. Well, maybe he's talking about that in the violent beating to my emotional well-being, because people, like, I've been going to counseling for years. I have nightmares about the police knocking on my door for some crap about Francina Evans, a woman I have a lifetime order of protection with that is completely unenforceable because of bias and racism in law enforcement. She's violated the order 17 times, people. She's never been charged. She's never been arrested, people. Something is incredibly wrong with the judicial system, and we're going to fix it. As a direct and proximate result of the actions of the defendants herein, Mr. Howard was caused to be falsely arrested, maliciously prosecuted, caused us the same mental suffering, anguish, psychological and emotional distress, loss of wages, loss of reputation, suffered embarrassment and humiliation, defamation of character, loss of properties, and deprivation of his physical liberty, deprivation of his constitutional and civil rights of the United States and New York State Constitution. Because of the proceedings, Plaintiff Howard was damaged in the amount of $5 million plus cost disbursements, attorneys, and legal fees. As to the second cause of action on behalf of the plaintiff. Actually, people, we're at an hour and a half, so we're going to stop today. We're going to call this part one of my factual account and deep dive into a lawsuit for the malicious prosecution and false arrest of myself as an innocent minority man that was caused by Francina Evans. my lying ex-girlfriend who was convicted of violating the New Jersey Prevention of Domestic Violence Act when she decided to lie through her teeth on me. Now, people, am I happy with this? Absolutely not, people. Do I want to do this? Absolutely not, people. Did I honestly want to sue the city of New York for the violations of my ex-girlfriend? People, no, I didn't. But at the end of the day, people, I had no choice. I had no choice because my ex-girlfriend was so determined to hurt me that what she did was lie to every law enforcement agency she could find between the state of New York and New Jersey, hoping that she could use the racism. Okay, people, we're back. I'm telling you, these Colombian Wi-Fi connections are horrible. What she did was use the racism and bias completely intrinsically buried in the judicial process of the state of New York and New Jersey to find the right racially biased and gender biased employees to help her violate my civil rights. And people, this was wrong. I was violated. My rights were deprived. I was deprived of my liberty, my freedom. The actions of my ex even interfered with the custody of my daughter, as she actually, because they would not enforce the order of protection, she felt completely protected. People, she actually violated the order so bad she started trying to make contact with the child the order of protection barred her from seeing. And this is proven by the mother of my child who reported it to the police, that Francina Evans and her mother, Laura Owens, were driving out to Brooklyn trying to bring gifts to my child, trying to have my child come downstairs so Francina could take pictures after she had lied to the mother and told the mother that there was no order of protection protecting the child against her and that the assault was a lie. The mother was so stupid in not bothering to investigate that there was an actual order of protection, allowed Francina contact with the mother, not my child. Francina never came around the child. That is one thing I will give my child's mother credit for. She wasn't stupid enough to bring my daughter around Francina again, but the fact that she even spoke to Francina due to her hatred and a need for revenge against me is what propelled this situation. So people, I had no choice, people. As an African American male, I had to use the one thing that could never be taken from me, and that is my ability to learn, comprehend, and apply knowledge effectively to protect myself and defend myself from these civil violations, racial improprieties, and racial injustice imposed on me by the city of New York, 120 Precinct, 121 Precinct, 123 Precinct, and the Staten Island District Attorney's Office. Like I've advocated, people, I don't speak against Michael McMahon because I'm just a angry black man who doesn't like white men. No, I know Michael McMahon is a racist. I've known him for 15 years. My mother was a personal associate of his. She was never a friend because no friend of my mother would have falsely arrested and prosecuted her son for allegations he knew her son were innocent of if he was truly a friend. So people, Michael McMahon has designated himself my enemy. He has taken the position of a man who wants to destroy me. So people, I accept war. I'm not a coward, and I choose to fight for my civil liberties and my civil rights by suing the Staten Island District Attorney's Office, holding Michael McMahon and his office accountable, and those detectives within the 120 and 123 and 121 precincts who violated my civil rights. This is part one of my explanation into the civil rights complaint filed against the city of New York and the Staten Island District Attorney's Office. I'll be back with episode 2 to discuss the second cause of action, third cause of action, and fourth, and also to break apart the systematic, statutory, and procedural injustices that happen to me. And the only reason I do this is because someone out there listening to these broadcasts, a father, an innocent minority, maybe someone who has an ex-girlfriend who is just trying to destroy you by abusing you with false reports. Hopefully you see this broadcast and you say, wait a minute, if this man was able to sit back and discipline himself enough to fight these corrupt people, then I can do the same thing. People, I'm not special. I'm one man who's focused on getting justice. I am determined to hold those accountable who lied on me, defamed me, tried to disgrace my dead mother, and deprive me of my child and my liberty. They are going to pay for it. And people, I'm not going to give up until I get justice. So tune in with me tomorrow for part 2 of how I'm suing the police and how you can sue the police through civil rights action, through civil rights litigation, and through civil rights activism. People, you have to speak up against your local law enforcement officials and police when you realize there may be misconduct, racism, or gender bias, because that's the only way we're going to truly fix the injustice and the broken system, which is the family and criminal justice system within the United States of America. I'm not even going to make it inclusive to the city of New York, because every state has its legal and its racial problems. Every state has its problems with the family court system with regard to them falsifying complaints against father, illegally depriving fathers of your 14th Amendment right to raise your child free of government intervention, people. And that's big. When the family court takes your child away from you and restricts your access when there are no allegations or nothing to substantiate that you are a danger or a negative impact of your child, they are interfering with your 14th Amendment protections, which grants you an uninterfered ability to raise your child. This is something, again, that happened to me, that was perpetuated on me because the Richmond County DA's office refused to charge my offender, who was actively trying to pursue my daughter while restraining order, preventing her from contact in any way with my child was against her. People, I seek justice, and I seek justice through the truth. I would never lie on Francina Evans. The truth of the matter is, people, I feel sorry for her. I never wanted her to go through this. I never wanted her arrested. People, I have proof that I tried to work with her brother so this would be handled without going to police. People, I was forced to go to the police because her, as a scumbag, lying black woman, decided to use law enforcement, the racism, the bias that is naturally inherent within the NYPD, to pursue me and get revenge on me because she was physically unable to get the revenge she wanted. So what did she do? She used her brain and her intelligence to manipulate these horny, unjust, racist law enforcement officers into riding with her against me. So since you chose to ride with her, you can die with her. And all of you will die in civil litigation when I expose you to be the corrupt, untruthful, unethical, unconstitutional, just unworthy individuals you are. Everyone, I appreciate you so much. Thank you for listening in. Thank you for supporting me. Please like, share, and follow these broadcasts. Share them as much as you want, people. All of us, single fathers, victims of domestic violence who may not be receiving the protections law enforcement are supposed to give you as the victim, people who are constantly ignored and violated when local prosecutors refuse to respect your rights as a victim. You can do this too. Do not think that the door closes when law enforcement won't help you. No. The process of law enforcement is meant to protect the state, its rules, its regulations, its procedure. The process of the civil court is meant for you to get your justice. Don't rely on the cops. The cops will never provide you justice, but the civil court will if you know what you're doing. And people, your mission as an individual, as a free American entitled to the use of the legal and the judicial system, is to learn your civil rights so you can fight back like I am. People, I'll continue to fight back. Spread my message. I'll be back tomorrow with part 2 of this, and we'll continue to go through the allegations, and then we'll walk through step by step what you need to do to file allegations like these to hold law enforcement accountable, because my mission as the executive chairman of Operation Rock Now is to educate as many people I can on how to hold these municipalities and city governments accountable for the illegal, unjust, and unconstitutional violations of its representatives, officials, and employees. Don't allow them to lie and tell you that they're immune just because of the 11th Amendment. No, people. Their immunity stops at a point. It stops when they commit criminal action. It stops when they falsify and commit fraud, people. And I'm going to help you people recognize it so we can hold them accountable. People, on behalf of Operation Rock, Happy New Year. And on behalf of a mother who loved me more than I will ever remember, my mission is to wake everyone up to the injustice of the family court system, to the injustice in Staten Island committed by Michael McMahon's office, to sellouts like Victor Brown, who would rather sell out innocent minority men based off lies so he can get protection and favors from the white man. This is a man who doesn't need to be a pastor. A pastor is supposed to be someone who supports, builds his community, and protects the innocent, not sets innocent people up because he may be attracted to the vagina of a younger parishioner as it is. And Victor Brown has a history of this. I'm sorry if you happen to be a member of Mount Sinai Church on Staten Island and Victor Brown is your pastor. He is corrupt, and my mission is to expose him however I choose to do it. And I can talk, people. I'm coming. So for 2025 and for Operation Rock, this is Clayton with the first broadcast of many more. And I'm going to teach hundreds of thousands of people how to sue the police and hold law enforcement accountable when they violate your rights. On behalf of Reverend Howard, my late beautiful mother, and on behalf of Operation Rock, Happy New Year, and we'll be back tomorrow with more on how you can hold law enforcement accountable when they violate your civil rights. Because people, that's all that matters. The only thing that matters is you obtaining the justice that you are denied through racism, bias, and discrimination, which was the whole point of the Civil Rights Act of 1871 with respect to minorities. The government, the powers to be, were violating the rights of minorities and trying to reinstitute slavery through instituting local practices and state laws. So the federal government created the Civil Rights Act of 1871, which subsequently led to Section 1983, 1985, 1986, all of which deal with how law enforcement violates the civil rights of minorities and protected classes of individuals. As an African American male, I'm a protected individual. I have rights. I deserve respect. And since Michael McMahon, Victor Brown, Detective Joseph Quirk, Detective Joseph De Palma, Courtney Chase, Mackenzie Upsaw, Gabrielle Giovinazzo, and the rest of the members of Safe Horizon and the NYPD refused to grant me those rights, I'm going to take them. And not by being a violent, ignorant black man, by impressing these people so and letting them know that I am no fucking idiot. I want my justice and I'm going to get it. So on behalf of Operation Rock, people, thank you for tuning in. I'll be back tomorrow with part 2, and we'll keep figuring out how you can hold law enforcement accountable when they violate your civil rights. I'll be back tomorrow for part 2. Thank you for listening. Love you all.